Hello, hi, and welcome to today's instalment in our Renters' Rights Act webinar series, where we're going to be talking all about the tenant's rights to request a pet. I'm David Hackett, Head of Client Management here at the DPS, and I'm very pleased to say we have the wonderful Suli Krola joining us again, as she is for this entire series from the Guild of Letting and Management. Hi, Susie. How are you doing? You okay?
Yes, very good, and very happy to be here. So looking forward to this session.
Lovely. Well, from our perspective at the DPS here, we'll always try and support and provide information where we can on the ever-changing industry that it is. And again, we're in very safe hands here today with Susie. So we're going to be talking about the wonderful world of these fluffy creatures that are out there and the tenant's right to request a pet. This information will be available on demand. You'll be able to share this with friends and family alike, and we'll give you more information about that at the end. So without further ado, I shall pass you over to Susie now, who will complete the webinar.
Thank you, David. Thank you. As you said, it's very much going to be about these fluffy creatures that tenants may ask consent to actually join them during their tenancy. So the objectives of this session, everything sits around the Renters' Rights Act. So topics that we've discussed before and topics that we will discuss on future sessions. And this particular session, as David said, sits around the tenant's right to request consent for a pet. So I just wanted to give you a little bit of background, because this topic has been widely discussed since 2019. Giving you some information, we've got a lovely pup there, and who could ever refuse that pup? But it's really, really important to know that as much as this topic might seem very light, there's a lot of history behind the onset and the publication of the white paper, and also the fact that I've given you information and also a link to a private members bill that was published way back in 2019 and sat around dogs and domestic animals within accommodation and obviously their protection. So a key topic, it kind of gathered momentum during and post-pandemic, because obviously many of us were at home during different stages of lockdown, and a lot of people wanted some sort of comfort during that very, very difficult time. So it is a given, and it is a scientific fact that, you know, having a companion, maybe a pup or a cat or another type of pet, does help physical and mental well-being. So this is where this topic stems from. So what's happened since 2019? Obviously, we had a previous government who looked very much at things through a different lens, and we had the Renters Reform Bill. That obviously didn't achieve the point of royal assent, and therefore we ended up with what we have now, which is the Renters' Rights Act, which I've abbreviated for you on screen. Now, Section 11 of the Act that amends the Housing Act to 88 establishes this not blanket ban. I really want to stress. The press put a huge amount of emphasis in terms of their headlines that the legislation, whether it was under previous government or current, would feature the fact that the landlord would be banned from refusing a request for a pet. That is not the case. What we have, and it's very, very different within this statutory framework, is the fact that the tenants will have the legal right to request permission to keep a pet. Okay, so that's really very, very important, and I've given you the various sections that this sits under and amendments as well. Now, it's important to understand that within the legislation, we have a definition of a pet. Okay, so as defined within the Renters' Rights Act, it's either going to relate to the fact that the pet sits around personal interest or hobby, forms part of a family and therefore provides companionship, ornamental purposes, i.e. Types of fish, bird, reptiles, caged type of animals, guinea pigs, micro pigs, who obviously are not caged but sit under that kind of combination of ornamental purpose or any combination of the above. So that's important to think about. The tenant's request obviously should be focusing on the pet. So the opposite to a pet is effectively, well, you know, I'm sure that scientists and biologists and specialists would disagree, but we're looking at the difference between an animal and a pet. Animals generally are kept outside, so I've given you an example of the type of animal. They don't necessarily come into the house or into a flat, and they are not domesticated. You also need to think about the type of animal that could be exotic. Tigers, obviously that's a very bizarre example, I'm sure. Wild animals and certain types of breeds of dog, which could be also deemed exotic. Think about what denotes a working animal, types of dog, assistance animals, sniffer dogs, shy horses, generally live outside or provide a service. Okay, so that's quite important to think about. And then thinking about the status also of animals that provide assistance. Now, this is really very, very important because there's a lot of discussion around comfort dogs, assistance animals, and I've given you basically a definition. Generally, they're working dogs, they provide assistance, they're certified, trained animals, and I've given you some examples of guide dogs, support dogs, cats, believe it or not, animals that provide that support for somebody that may have autism, that may have suffered a stroke, hearing dogs, medically trained dogs, and even police forces. I know that seems a little bit odd. So that kind of gives you an overview of what we're talking about. So I just want to touch on disability and animals because, as I said, this status, and I put this statement back onto this slide. Again, we're giving you some more additional notes. Under the Equality Act, somebody that may have a disability may require an animal for assistance. So it's important to understand that this will be governed by a different area of law, not the Renters' Rights Act, but it will be governed under the Equality Act 2010. So please do have an understanding that if somebody does ask you for consent, think about the kind of animal, think about the kind of pet, think about their requirement, and have a discussion around that, okay? Because generally these types of animals are certified and trained, okay, and therefore a purpose, okay? I've also added right at the very bottom of this slide that the Equality Act will override contract law, okay? Well, I'll explain why I've added that to the slides. So the tenant has this legal right, which begins on the 1st of May 2026, to put a request to the landlord for a pet. The request has to be made in writing, and I really want you to think about this. Often people talk to us and other stakeholders, you know, for example, DPS and people and organisations that have vested interest in this legislation. The legislation is written for two sides, and in this case, landlord and tenant. So it's important to understand that there are things that the tenant will have to do to comply. And one of those things is to provide information, and as much information as possible, including obviously a description about the pet in question. Now, if the tenant doesn't provide any information, not a little bit of information, but no information at all, the landlord can refuse consent. Okay, so that's really important to bear in mind. The landlord must provide a written response. So the tenant will make the request, just hypothetically, on the 15th of May 2026, and 28 days from that day, the tenant must receive a response from the landlord, either granting or refusing consent. Okay, so that's very, very key. So, can the landlord and tenant mutually agree to extend this response deadline? And the answer to that question is yes. So it could be that the landlord requires additional information from the tenant and puts in, you know, that request to the tenant, or, and this is probably going to be very, very common, the landlord needs to obtain consent from superior landlord freeholder because the property in question is a leasehold property. So that's important to bear in mind, because sometimes it could be that the information we're waiting for could take much longer than 28 days to achieve. If the landlord does not respond at all to the tenant's request, the tenant could pursue the matter through the first tier tribunal or the courts, and then the landlord will be required to fulfil their legal obligations. Okay, so there's always something, a consequence that will take place even if landlords don't give consent and ignore the tenant and so on. So think about refusal. We know that we have a 28-day window to provide the tenant with consent or not. So that's absolutely fine. We will have a further 7 days to give the reason why consent has been refused. Okay, so that's effectively a 35-day window. Now, the information on screen gives you an indication of reasonable reasons where consent could be refused for a pet. Okay, and there's been a lot of discussion around this, and I'm sure there will be a lot of questions, you know, moving forward throughout the rest of 2026 into 2027 as we get used to this process. So one of the elements is allergies, the fact that the property is not suitable, it could create overcrowding, or there could be a breach of licensing criteria. The tenant has made a request for a pet, but the number of pets far exceeds what could be deemed reasonable. Okay, so very important. And then the type of pet, and I've given you an example because there is always a discussion around fish. The tendency tends to be around goldfish. Is that a problem? But here we're talking about fish in a tank, the fact that the tank could cause excessive condensation, which could cause a problem depending on the type of property. So that could be a reason to refuse. Again, the type of pet could be a dangerous dog breed, and you can find that information online. There is a huge raft of legislation that sits around animals, domestic or otherwise. Size of pet, I've put llama. You know, you might think why, but we need to look at this on a case-by-case basis. So, for example, if a tenant said to you, could I have a pet llama? And it's a one-bedroom flat, then we know that the answer is going to be no. If the tenant is taking a property that is in the countryside, the garden is quite big, there's ample space, the landlord may say yes. Okay, so we also have to look at the fact that the request is reasonable versus unreasonable. So I just want to think a little bit about restrictive covenants, because this is one of the areas that I've not put on the previous slide, because it sits really well on its own. So the head lease is effectively the principal lease, which is granted by the freeholder to leaseholders. And in this case, the leaseholders that we're talking about are people, the letting agents. And obviously, if you are a landlord, you could or would be a leaseholder. The lease, it effectively is the overarching set of rules that sits above any other contract that's in place. And it basically provides leaseholders, occupants, tenants with a set of rules and boundaries that they have to abide by. Okay, so that is really important. Types of restriction can vary, but for the purpose of this webinar, we're talking about restrictive covenants in relation to pets. So the restrictive covenant could be an absolute ban on all pets, and if you've read your head lease, you will see that it doesn't just refer to pets, it refers to animals, it refers to reptiles, it refers to birds, you know, it covers a whole range. So that would be an absolute complete ban. Or it could be a conditional restriction, and the conditional restriction means that the leaseholder, so landlords, will have to get consent in writing from the freeholder. Okay, so that is really very, very important to bear in mind, because that's one of the reasons that is deemed reasonable, but you have to look at what your head lease says. Okay, so that's key. That's a key point to bear in mind. Enforceability of the head lease. If the head lease prohibits pets and animals, the landlord cannot give consent. Okay, so it will be there in writing, it's very clear, there's no ambiguity, there's no grey area, there's no misunderstanding. Now, if the tenant or the occupier breaches the head lease, breaches that covenant, this is one of the consequences that the majority of people do not understand, especially tenants and sometimes even the leaseholders, that this could lead to legal action. Okay, so it's really important to understand, what does that head lease say if you have leasehold properties that are flats, apartments, and sometimes houses. You need to check what the rules are. So that's very, very key, because that could end up with the leaseholder, landlord, facing an injunction, having to pay damages, and even worst case scenario, forfeiting the lease. And that's not a good thing. Okay, so bear that in mind when we're talking about and thinking about restrictive covenants within the head lease in relation to pets and animals. Unusually, I say this because I don't personally, in the work that we do, see this very often, is that some covenants are absolute, but it may be possible to negotiate a deed of variation, and that would require some very serious legal advice, some very key support from your legal representatives, and it could be that the covenant is relaxed a little bit through a deed of variation, but you would want to get legal advice on that. Okay, so that's very, very important. So we've talked about the fact that landlords do have the right to refuse consent, and the reason mustn't be unreasonable. It's got to be a reasonable reason. And we've thought about the type of property, the type of pet, the request being related to a leasehold property, where there is a restrictive covenant. So they're all reasonable reasons. But I've given you some examples of unreasonable reasons, which have actually come from landlords. So, for example, the landlord doesn't like pets, full stop, doesn't want a pet, thinks, even without having any knowledge of that pet, thinks that the pet may damage the property, is concerned about pet smells, odours, and the impact on future tenancies, or that the landlord has had a bad experience in the past. Now, one of the things that came up on a previous session, and this was through the Q&As, was that what happens if the landlord was attacked by a pet that was owned by a previous tenant, and that obviously could create problems for the landlord, PTSD, serious phobias, and so on. Okay, so that could be, whilst we talk about a bad experience in the past, it really does depend on what happened. Or the landlord is concerned about noise. Now, you may say, well, that's a genuine, fair reason. It's not unreasonable, but we don't know if there will be any noise, okay, because we don't know what's going to happen in the future. It could be that that particular pet makes absolutely no noise. Okay, so this is going to kind of be a work in progress effectively, and I'm sure that you can think about lots of reasons why you might refuse consent that I haven't thought about. So let's think about the fact that the landlord has granted consent, and as you can see, there's a lot of information on this slide, and this is going to go on for a few slides. So we're thinking about, we've granted consent, we have a very happy tenant, which is great, and then there are certain things that we need to adhere to. Now, because we are in future sessions going to talk about paperwork, I just want to set something out here, is if you do grant consent for a pet, this needs to be documented in writing, in the written statement, in the form of pet clauses. So the landlord would set out some very clear criteria that the pet owner must adhere to, and that will then be translated into the assured periodic tenancy. So I've just given you some examples from a pet policy that tenants are responsible to ensure that the pet is looked after in line with the Animal Welfare Act. Okay, so the premise behind the white paper originally sat in relation to responsible pet owners. So we would expect that of the pet owners in question, that they make sure that they do not abandon their pets, that they think about ensuring that the appropriate animal welfare is in place. We would expect these tenants not to leave their pets unattended. Have they made arrangements to make sure that dogs, in the main, are not left for an extended period of time on their own? And I know that you may be thinking, well, how can we insist upon that? But that may be part of the criteria that we need to think about. We want to make sure that the tenant doesn't damage the property if they are left unsupervised. Okay, so that is one of the big things for landlords. At the point of moving out, and you know, obviously I'm in an environment working in association with DPS, who have a huge amount of information on this particular slide that you can find on their website. You can find examples of cases that have been dealt with through ADR as well. We have an expectation that tenants clean the property thoroughly when they move out. De-infestation, defumigation takes place. These are all things that you can keep very, very clearly in writing and make sure that the tenant is aware of this. Tenants are responsible for keeping the property clean and free from parasites and so on. And tenants must ensure that their pets, and it's not just dogs, do not cause excessive noise and do not cause a nuisance, okay, so that they're kept under control in public places, communal areas and walkways, let's say within the communal areas of a block of flats and so on. Again, we would hope that the pet, and we're thinking here probably about cats and dogs, are properly trained to use a litter tray and not to use the property as their bathroom, and that any pet feces are removed from the property. Okay, and we're thinking about hopefully just gardens and outside areas and disposed of, safely, because this is really, really important to landlords. Okay, the landlord is being given a statutory obligation, but also remember that if the tenant is granted consent, the tenant needs to abide by certain rules and terms of the contract. Again, one of the things that we've done, and we've put together a pet profile, and all of this that I've already discussed will appear on the pet profile that a tenant submits to the landlord before the landlord makes a decision or not to grant consent. So things like that the tenant make sure that their pet is vaccinated. Okay, so that's quite important. The pet in question is not on the list of a dangerous wild animal in terms of legislation that exists. That's not acceptable. And also the dog in question does not feature in the list under the Dangerous Dogs Act of 91. Tenants shouldn't be using the property to breed puppies or any other type of animal. Okay, so that is not acceptable. And obviously, tenants who wish to obtain an additional pet after move-in, obviously under the Renters' Rights Act, must put that request again in writing from the landlord and, where applicable, letting agent, who then will have a discussion with the landlord. So how do we keep a record of condition? And this is something, again, you can find a huge amount of information on the DPS website in relation to setting the standards. We make sure that we have a really strong inventory and check-in with photos, with very clear indication of what the condition is in real time at the point of move-in. Okay, those documents are just worth their weight in gold. Okay, so that's how we keep a record of condition from the point that the property is let for the very first time. How do we continue monitoring condition? And one of the prerequisites generally, if you are working with a letting agent and the letting agent is managing your properties, then the letting agent will provide a service within which there is the request depends on frequency for property inspections. So these property visits are really, really important on so many different levels. And we're not just thinking about the property without pets, we're thinking about the property with pets. Okay, so we know that the tenant has been granted consent. We're going to carry out a property visit. We're going to document everything in relation to condition, maintenance, repair, and so on. But if the tenant was never given consent, then potentially we would also document the fact that the tenant is in breach of the tenancy agreement. Okay, and the first point of reference, because you will know if you're a landlord, and you'll definitely know if consent was given if you are a letting agent managing the property. The first point of reference is the information pre-tenancy. Okay, did the tenant put the request in writing? Did they provide information? Did the landlord give consent in writing? Did the landlord refuse consent and provide a reason why? So we would check that, okay? If there is a breach, you must notify the tenant in writing. You know they're in breach, the tenant knows they're in breach, but we have to cement that in writing, okay? And we give them time to remedy the breach. And there are lots of different possibilities, okay, here. It's really, really important to understand that it's not easy to navigate a breach of contract, especially in relation to pets. Advise the tenant of the breach, but also advise them potentially there could be a notice served. And that notice I've made reference to on the slides. It would be Section 8 under Ground 12. And then in brackets, I've also added the grounds 13 and 15, all of which are discretionary grounds, so you need to have a lot of evidence. Okay, 13 and 15 relate to damage of furniture. It could be that the pet has caused damage and deterioration of the property as a result of having pets. So there are avenues that landlords can pursue. But it's important to understand, especially if it's a leasehold property and there is a breach in relation to pets, that could cause serious consequences for the landlord. Okay, so navigate these situations well and carefully. So think about deposit deductions and pet damage, and as I've made reference already, thinking about a condition. So where a pet causes damage, for example, to doors, carpets, fixtures, flea infestation, the landlord may want, not even may, will want to recover reasonable costs. Okay, so all the deposit protection schemes, they require really clear evidence. The more information the landlord has, the agent has, that they submit, the better, okay? You cannot just expect to make a claim based on the fact that the tenant had a dog. That's not enough information. You need chapter and verse on how the consent was given, the fact that there are clauses in the contract that stipulate what will be done and how things will be dealt with if the pet does cause damage. And obviously I've mentioned the fact that there's, a comprehensive inventory in place, schedule of condition, photographs, everything that is signed and dated by the tenant, so that we have a very clear record. In relation to the tenant vacating, the checkout report. I've been doing this job a very, very long time, and there is none of those documents, inventory, check-in, property visits, and checkout. None are more important than the other. They're all equally important. So you have to be really clear about your paperwork, okay? Do not think that these documents are not valuable, because they will help you, even though you did give consent, demonstrate what condition was at the point that the tenant took on the tenancy and at the point that the tenant has now vacated. Okay, so you need to be able to demonstrate deterioration and damage, and that will be done in writing. Wear and tear versus damage. Now we know, because tenants deposit protection, the schemes, all the criteria has been around since 2007. Okay, so that's quite a long time. So we're really very much used to this process. We understand what fair wear and tear is that's normal use of the property, and we understand that we can't make deductions for those things. However, when we're talking about the fact that the pet has caused damage, and this is one of the concerns for many landlords, and it should also be for tenants, is the fact that if the pet in question has caused significant damage because they've been chewing the furniture, or they've been scratching the curtains, or they've caused infestation, or one of the things that is very challenging, the odours in the property are horrendous. That's not wear and tear. Even to the extent of damage caused by burrowing in the garden, that's not wear and tear. So the tenant needs to understand, just based on those points there, that they need to make good. They are the responsible pet owner. Okay, it's down to them. So the landlord obviously will be aggrieved because they won't be happy, and there needs to be a very clear understanding at the outset that the tenant is responsible for any damage caused by their pet. Okay, and that's why we have lots of documentation to support this information. I want you to understand that if the landlord thinks they can claim on insurance for pet damage and then seek more money through the deposit, that effectively will be a double recovery, and the landlord can't claim twice for the same thing. Okay, so they're either claiming via the deposit, or they're claiming through insurance for pet damage. Now, just on that point, and this is a lovely segue, I just want to clarify two things. There was discussion over the last, I would say, 12 to 18 months before Royal Assent was granted, that potentially landlords would be able to ask tenants to obtain insurance against pet damage by law. That has been removed. So the landlord cannot insist on the tenant obtaining insurance for pet damage. If they have it, great, but it's not something that they can force. The other thing that landlords cannot request is a much higher deposit. Okay, the government made it really clear that they felt that 5 or 6 weeks equivalent of rent as a deposit is absolutely fine. So I really don't want you to get caught up in those discussions because they are no longer relevant. Pet-related damage could be way over the deposit amount. Okay, so the landlord may only have access to 5 weeks deposit, but in fact the damage caused is in excess of that amount, and the landlord therefore have to make a claim via the courts. Okay, so that is not just in relation to pet damage, that's in relation to any type of damage. Okay, so we need to be very clear on that point. I've put this in because I have been fortunate enough to work alongside someone who knows more about legislation related to pets and animals than I do. And it's huge. It's a huge topic. We are a nation of animal lovers, as you can see, and this is just a tiny example of what's out there. But I've given you information because you will find situations, hopefully not frequently, where perhaps a tenant has vacated, having left their pet behind, and that's not a great situation to have to deal with. You may come across situations where the request for the pet involves a pet that is on the list underneath the dangerous dogs legislation. So that's important for you to be aware of. And then animal welfare. We're thinking here, there's been a lot of discussion around the fact that the tenant should have the right to request a pet for lots of different reasons. But it could be that the tenant doesn't actually look after the pet at all. So there are a lot of organisations that have done a lot of research that are very well respected. The Dogs Trust, Cat Protection League, Guide Dogs UK, Battersea Dogs and Cats, Blue Cross for Cats. Lots of organisations where you can obtain a lot of information where you may feel that the request is being made, but the tenant isn't actually thinking about animal welfare. Okay, so all of this legislation is available online. Interestingly enough, a lot of the legislation is currently going through the process of being updated. Okay, so these things will help you, and I think will be extremely useful. And obviously, right at the very bottom, we have the Renters' Rights Act, which is what all of this is actually about. Okay, so that's effectively the end of the presentation. I hope that has been useful. One of the key takeaways is to make sure that you think very carefully about the processes that you have in place as the 1st of May approaches. Okay, so some key things that you need to think about. When you are gathering information, the simplest thing is to have a pet profile, and people refer to it as a pet passport. That's something completely different if you want to travel with your pet. But a pet profile is a very simple document that the tenant can complete, giving you all the information that you require. Some template letters that might be really useful. Template letters that advise the tenant that you, as the landlord, have granted consent. Okay, so that's going to be really important. The opposite of that is a template letter that stipulates that the landlord is not granting consent. Okay, so those two things work together. And then the final piece of information is if you do give consent, make sure you have a really good, clear set of pet clauses, what I call a pet policy. Okay, and we've given you an example of some of those points throughout the webinar. Okay, because in giving consent, the tenant needs to understand that they need to adhere to certain rules in terms of how they look after their pet, how the pet behaves, and so on. So think about those things very carefully. I do hope that this has been useful. I'm sure that you may have questions in the future, but remember that tenants do have this right, and try to navigate it in the most professional fashion possible.
Amazing. Thank you so much, Susie. There's so much information in there, and it's always topics that may seem quite obvious at face value, but when you dig into it, there's a lot of content, and there's so from our perspective, for our users at the DPS, it's an absolute pleasure to have you with us. Whilst I know this content, for those of you watching, does not belong to the DPS, so if you have any specific queries, you can speak to the fantastic team over at the Guild of Letting It Management via the details on screen. For more information on government guidance generally on the Renters' Rights Act, you can follow the link below in the housinghub.campaign.gov.uk. There'll be more information there. In terms of deposit protection, if you have any concern about things relating to dispute resolution, end of tenancy, adjudications, etc., we have disputes landing pages and learning hubs on our website as well. So feel free to reach out to us with queries regarding that. But all that's left to say for me is a huge, huge thank you, as always, Susie, for you educating us all on this. And again, anybody watching, feel free to share with friends and family after this session. And please do get in touch with the Guild of Letting and Management if you'd like to hear more about more of their training courses. So a huge thank you, Susie, and enjoy the rest of your day.
Thank you.
Take care. Bye-bye.